Good day, everyone. Thank you for joining us for this webinar in support of our automated vehicle safety reforms consultation that we have currently underway. As many of you would be aware, and many of you have been on this journey with us since 2017, this is the latest consultation in the development of the end-to-end regulatory framework for automated vehicles that has been progressively worked on by the National Transport Commission, the Commonwealth Government, as well as all states and territories. My name is Michael McCarthy, and I'm Strategic Engagement Advisor at the National Transport Commission. And with me today is my colleague Stephen Burshier, as well as Alice McRory from the Department of Infrastructure, Transport, Regional Development, Communications and the Arts. And both will present to you today on specific elements of the emerging regulatory framework that is to support the safe use of AVs on our roads. Alice, who is the Director of Automated Vehicle Regulation at the Department, will speak to the development of the National Automated Vehicle Safety Law, or AVSL, while Stephen, who is Principal Policy Advisor in the NTC's AV programme, will talk to the obligation of human users and potential required changes to state and territory laws. Before passing over to Alice and Stephen to lead today, I'll run through some quick housekeeping with you all. We anticipate it'll take probably 40 to 50 minutes to run through all today's slides as part of this presentation, after which we will stop for questions, so all attendees can put any questions you might have to either of our two presenters. At the time, there will be two ways you can ask a question. One, you can raise your digital hand, after which then I'll come and give you access to your microphone so you can unmute yourself and put your question to one of our two presenters. Or alternatively, the chat tab should be shown for everyone as well. If you'd like to record your question at any time throughout today's presentation, please put it in there, and we'll come back to those questions again at the end of the presentation and hopefully get to as many of them as possible. One quick thing I will note is for those who may be joining us this webinar, this Microsoft Teams webinar from your internet browser, for some and largely dependent on your own organization's IT restrictions, the presentation on your end may not necessarily stay in sync with our presenters as we move from slide to slide. If this is the case for you, what we will do as we move from slide to slide ourselves is we'll note when we change slide and call out the slide title, just so you can continue to move along yourself through the arrows at the bottom of the screen. But for 95% of people on the line today, this shouldn't be an issue. And finally, what you will have noted when you entered the meeting, the recording pop-up. It is our intention to record this webinar today as well, so we can put a recording on our website. So for anyone who wasn't unable to attend today or the webinars later in the week, you will be able to watch back at your own leisure. So we will make that live on our website shortly after this. And with that, I'll hand you over to Alice to kick things off.
Thanks, Michael. I'd just like to begin by acknowledging the traditional custodians on the land that we're meeting on today. For me in Canberra, it's the Ngunnawal and Ngambri people, and I'd like to pay my respects to their elders past and present, and extend that respect to Aboriginal and Torres Strait Islander people present today. So in today's presentation, I'm going to provide an overview of the key elements of the end-to-end regulatory framework for automated vehicles, outline why we're undertaking further consultation, and discuss the options we're seeking feedback on as part of this consultation. As Michael mentioned, the Department and National Transport Commission are consulting on the regulatory framework to support the safe use of automated vehicles on Australian roads. And this is a framework that's been developed over several years with significant previous work by the National Transport Commission together with state and territory and Australian governments, and several periods of public consultation since 2016. So in this consultation, we're seeking feedback on some specific aspects of the framework, and we've published a consultation package that includes a central paper and that outlines the proposed end-to-end regulatory framework for automated vehicles in Australia and introduces the key areas we're seeking feedback on. And this overarching paper is supported by a number of detail papers that explain key concepts, expand on previous policy work, or explore new areas of policy. You can find all of those papers on the NTC's website at ntc.gov.au/AV safety reform. And so that consultation package, it's intended to explain the regulatory framework and all the work that's already been done, but also invite your feedback on the framework through some specific consultation questions. The consultation is open until 11th of June, and we're hoping to hear from a wide range of stakeholders. So if these reforms are of interest to you, I'd encourage you to check out the consultation papers and consider making a submission. So to set the context for the rest of today's presentation, I'll give a bit of a rundown of what the technology is that we're talking about here, and why we're working on new laws and some of the key elements of the proposed regulatory framework. So to be very basic about it, automated vehicles are vehicles that have an automated driving system. And an automated driving system is a combination of hardware and software that is capable of driving a vehicle without a human needing to be in control or supervising. And automated driving systems are only able to operate within the operating conditions they're designed for. In Australia, we don't have any automated vehicles for general use on public roads available at this point. There have been some small scale trials on public roads in Australia, and there is some early automated vehicles being used on private land in Australia. So that's things like in mine sites, there's extensive use of automated hauling trucks and things like that. And also in agriculture, we see some use of automated vehicles. So probably a key thing for me to be clear on at this point is that the reforms we're talking about here today are about the use of automated vehicles on public roads. In other countries, automated vehicles are being used in larger scale public trials, and there's been some limited commercial deployment. And based on available projections, we're preparing for the possibility of small numbers of automated vehicles entering the Australian market from 2026. However, we're always interested in feedback on whether those forecasts need to be updated. So we need new laws tailored to automated vehicles to ensure safety on public roads. Our existing laws apply to human drivers. So without new laws, we won't have the right tools to manage the safety of automated vehicles. We also want to make sure the new laws are as consistent as they can be across Australia, so it's easier for automated vehicles to operate here. So now I'll run you through a few of the basics of the automated vehicle regulatory framework, and I'm moving on to slide 2, which is titled Automated Vehicle Regulatory Framework. So the Automated Vehicle Regulatory Framework, it will include a new Commonwealth Automated Vehicle Safety Law, or AVSL, complementary state and territory legislation, and existing Commonwealth legislation, like the Road Vehicle Standards Act. The Automated Vehicle Safety Law will place responsibility for the safety of an automated driving system on a corporation and not the human driver. This corporation, known as the Automated Driving System Entity, or ADSE, needs to have the right skills and capacity to look after the automated driving system over its operational life. This will ensure that parties with the most influence and control over the automated driving system safety can be held responsible for it across the system's on-road life. Ensuring that an entity is responsible for the safe operation of each automated driving system is important for the safety of all people who use public roads, not just the people who may choose to use an automated vehicle. The AVSL will also establish a new in-service safety regulator that will oversee automated driving system entities and ensure compliance with the new law. The regulator will have powers to enforce the law and the duties and enforce the law if the duties and obligations under the AVSL are not met. The AVSL will be supported by complementary changes to state and territory legislation and to existing Commonwealth legislation, such as the Road Vehicle Standards Act. Together, these laws will form the end-to-end regulatory framework. This includes making sure an automated vehicle is safe when it is first supplied to Australia, including that it meets any relevant technical standards for an automated driving system, ensuring that there is an ADSE to take responsibility for the safety of the automated driving system for its on-road life, keeping the automated driving system safe when it is operating on the road by placing clear safety duties and other obligations on the ADSE and its executive officers, and ensuring that people use and interact with an automated vehicle understand what their roles and responsibilities are. So these laws will create the regulatory arrangements to enable safe operation of automated vehicles on our roads, and should help Australia to gain the potential benefits of automated vehicles. So in terms of what we're consulting on in this round of consultation, basically as we were developing the automated vehicle safety law as a Commonwealth law, so we've been working on this following a decision in February 2022 by infrastructure and transport ministers from all jurisdictions that the automated vehicle safety law will be implemented as a Commonwealth law. So as we've been unpacking that, we found that we needed to further develop or adapt some of the policy settings to fit into the Commonwealth legislative environment. And so in this consultation, we are also taking the opportunity to explain the framework as a whole. And I think that's generally because we find it's hard to talk about only one segment of these reforms because they're all connected. So the focus of this consultation is on areas of policy that we've either further developed or adapted. And these are around how to ensure the safety of remote operation of vehicles with an automated driving system, whether we need additional measures to manage the safety influence of repairers, maintainers, and modifiers of an automated driving system, ways to promote consumer understanding of automated vehicle capabilities, obligations for users of vehicles with an automated driving system under state and territory laws, and finally, whether measures are needed to control the risk of deployment of automated vehicles before the regulatory framework is in place. So for each of these policy areas, the department's developed some options in conjunction with the National Transport Commission and states and territories. And I will go through the options for the areas relating to the Commonwealth law, and Stephen from the NTC will discuss the obligations for users of a vehicle with an automated driving system later in this session. So moving to slide 3, remote operation. Management of remote driving was considered in the end-to-end framework that was published in 2022. That framework proposed that prescriptive rules to regulate remote driving would be made under a head of power in the AVSL. We're revisiting this approach for a couple of reasons. Firstly, a head of power to regulate remote driving might not capture other forms of remote operation that do not involve remote driving. For example, where the automated driving system remains in control of the vehicle but receives some direction from a remote operator. And also, regulating remote driving through a head of power could also inadvertently capture forms of remote driving that might not be sensible to be regulated under the AVSL. So, for example, where remote driving is happening in a vehicle that does not have an automated driving system. So as a result, we're now considering some more targeted measures to manage the potential safety risks that may arise from remote operation, things like connectivity and cybersecurity risks. Remote operation can include a range of activities, including remote driving, remote ADS assistance, and remote assistance that is more focused on passengers or cargo. For the purposes of including additional measures in the AVSL, we're proposing that remote driving and remote ADS assistance that facilitates trip continuation when an ADS encounters a situation it can't manage, or to otherwise ensure the safe operation of a vehicle with an ADS, are the most relevant forms of remote operation to consider. So we think that forms of remote operation that are more focused on managing passengers or cargo might be more suitably addressed in other regulatory frameworks, such as passenger transport regulation. And forms of remote driving that don't assist an ADS to continue its journey would also be out of scope for the AVSL. So for example, when remote driving is happening of a vehicle that does not have an automated driving system. We're considering a number of options for including additional measures in the AVSL to manage the safety risks of remote driving and remote ADS assistance. The measures we are exploring would be intended to apply only to the extent that the ADSE uses remote driving or remote ADS assistance. They wouldn't make it compulsory for an ADSE to use remote driving or remote ADS assistance as part of its operations. We're considering whether the AVSL should place a duty on the ADSE to ensure the safety of remote operation. To meet this duty, the ADSE would need to have sufficient oversight of remote operation performed in relation to its ADSs, and would also need to ensure that remote operation is provided in a safe way by appropriately skilled and trained operators and in accordance with road traffic laws. Alternatively, the AVSL could also provide for a separate party to be responsible for the safety of remote operation rather than the ADSE. So this would enable a separate entity to take responsibility for the safety of remote operation and be subject to duties and obligations under the AVSL, similar to those I just described that would apply to an ADSE. Similarly to an ADSE, if a separate entity were to be responsible for remote operation, it would need to meet some certification requirements as well to ensure that it had the right skills and capacity to safely manage remote operation. So adopting this approach may provide greater flexibility in business models for ADS deployment, but may also, I guess, introduce extra regulatory complexity by having multiple parties subject to safety duties for the operation of one ADS. Individuals who perform remote operation will also have an important safety role. So we're considering whether it's necessary to place a supporting safety duty on remote operators, so the individuals that are providing a direction to an ADS or doing the remote driving. This duty would require them to perform remote operation safely and to comply with reasonable directions of the ADSE. And this recognises the impact that remote operation may have on road safety and supports the ADSE's safety duty to ensure remote operation. Finally, for remote operation, we're also exploring whether the AVSL should include a requirement that remote operation be performed from within Australia. So remote operation performed from overseas could result in safety issues such as communication latency issues. And there may also be barriers to the regulator exercising its powers under relevant legislation in an overseas jurisdiction. So requiring that remote operation is performed in Australia would help address these risks. I'm now moving to slide 4, which is additional measures for repairers, maintainers, and modifiers. The AVSL will primarily regulate automated driving system entities, ADSEs, as the party with the greatest influence on the in-service safety of an automated driving system. However, work done on an automated driving system by other parties also has the potential to influence safety. The previously agreed policy framework proposed to manage this risk through a third-party interference offence, which would apply where a person made repairs or modifications to an automated driving system that were not authorised by the ADSE. In addition to the third-party interference offence, we're considering whether there needs to be other measures for vehicle repairers, maintainers, and modifiers within the AVSL to directly manage their influence on the safety of an automated driving system. One option is to include an express requirement in the AVSL that an ADSE must authorise repairers, maintainers, and modifiers to perform work on its automated driving system. We think this is a useful complement to the proposed third-party interference offence, as it will provide a clear expectation around the ADSE authorising works on its automated driving system. Given the ADSE is responsible for the safe operation of the ADS, it's important that the ADSE understands who is working on its ADS and can ensure that they have the capability to perform that work correctly. The requirement that an ADSE expressly authorise repairers, maintainers, and modifiers could take different forms, and that depends a bit on the level of control and oversight that the ADSE has of the authorisation and work performed. For example, this could range from the ADSE having complete discretion about who it authorises to work on its ADS, through to the ADSE having an obligation to authorise repairers, maintainers, and modifiers if they meet particular criteria, in which case the ADSE would have less discretion over who it authorises to work on its ADS. In a circumstance where the ADSE has less discretion, this may need to be balanced by placing greater responsibility on those repairers, maintainers, and modifiers for the work they perform. We also recognise that requiring an ADSE to authorise and oversee repairers, maintainers, and modifiers may have impacts on competition and reduce an owner's choice of who can work on their automated driving system. So to address these potential impacts and support competition, the AVSL could also require that ADSCs not unreasonably withhold authorization from repairers, maintainers, and modifiers, and requirements around sharing particular information that's required for repairers and maintainers and modifiers to do works on the ADS. Even if an ADSE does everything that is reasonably practicable to ensure the safety of its ADS, the acts of or omissions of a person repairing, maintaining, or modifying an ADS can still result in safety risks. So to address this risk, we're considering whether the AVSL should include a safety duty on repairers, maintainers, and modifiers of an automated driving system. This duty would require repairers, maintainers, and modifiers to undertake work on an automated driving system with due care and in accordance with the ADSE's authorization. Safety duty on repairers, maintainers, and modifiers would support the ADSE's primary safety duty to ensure the safe operation of an automated driving system. To make sure that consumers know which repairers, maintainers, and modifiers are authorised to work on a particular automated driving system, we're considering a requirement that the ADSE share information about authorised repairers, maintainers, and modifiers on an automated vehicle register. So this set of measures are intended to recognise the influence of other parties like repairers, maintainers, and modifiers have on the safety of an automated driving system and increase accountability for safety on parties that have the ability to influence it. I'm now going to move to slide 5, which is consumer information, and turn my light back on. In terms of consumer information, a lack of understanding of how automated vehicles differ from conventional vehicles could have consumer and safety impacts. So here we're thinking of things like an ADS needing to be decommissioned at the end of its on-road or design life, and the ADS not operating outside of its operational design domain, as well as the varying roles and responsibilities of humans in the vehicle, depending on things like its level of automation. A number of measures already planned under the AVSL to address consumer impacts include establishing an automated vehicle register to make sure particular information is available to consumers, and a requirement for ADSEs to provide education and training to support consumer understanding of automated vehicles. So while these measures may address some consumer issues, we think there are further measures worth considering. Firstly, the AVSL could require ADSEs to ensure certain technical information is provided to consumers so they can understand the potential impacts before purchasing an automated vehicle. So, or also as well, I guess, a service based on an automated vehicle, acknowledging that private ownership might not be the only model here. You might subscribe to a shared vehicle service, for instance. So the kinds of information we're thinking about here is information about design life, which is the period of time that the automated driving system entity has elected to support that automated driving system. The operational design domain, so that's the set of, the conditions and locations in which that automated driving system can safely operate, and the level of automation of the automated driving system and what that means for the vehicle user. We're also considering whether the AVSL should include offences for misleading marketing of vehicles with automation, and these offences would be intended to apply broadly to anyone undertaking marketing of a vehicle. So that would include misrepresenting a vehicle's capability or implying that a vehicle has an automated driving system when it does not, and using restricted terms to describe a vehicle that does not comply with the relevant national road vehicle standards for an automated driving system. Restricted terms might include things that could only reasonably and safely be applied to a vehicle with an automated driving system. For example, describing a vehicle as driverless or self-driving. And so this is similar to an approach being considered in the United Kingdom as part of their automated vehicles bill. I'm now moving on to slide 6. Which is deployment ahead of the regulatory framework. So the timeframe for deployment of automated vehicles is still uncertain. And as mentioned earlier in this presentation, previous projections suggested some vehicles with conditionally automated features may be available around 2026 in Australia. And we are interested in learning more about whether these projections have changed. Outside of approved trials, any introduction of automated vehicles on public roads can bring new risks that can't be managed with our existing laws. We have put forward two potential options to limit the availability of automated vehicles ahead of the commencement of the proposed regulatory framework. The first option is introducing new requirements under the Road Vehicle Standards Act to restrict the supply of vehicles with an automated driving system to the market. This measure could include an exception for a vehicle that's to be used as part of an approved automated vehicle trial. Another option is to introduce interim restrictions on installing or using an automated driving system under state and territory law. This would complement any requirement under the Road Vehicle Standards Act and will limit the risks of aftermarket installations and use of unsupported automated driving systems. We're also considering changes to the automated vehicle trials framework, such as more consistent approaches to governance arrangements like risk management and information sharing, and establishing objectives and priorities for trials like cross-border trials. We're interested in learning more about any current barriers to complex and large-scale trials in Australia. Further to this, we're also exploring the potential for the AVSL to include an option for interim ADSE certification, which would be intended to be used for trial arrangements. So an interim ADSE certification may have different requirements to, I guess, full ADSE certification that would recognise the different characteristics of undertaking a trial. And this would help provide a clearer pathway to move from trials into commercial deployment under the AVSL and enable the regulator and trialling organisations to work together and better understand the regulatory requirements and practical issues of a, in the context of a trial before moving through to commercial deployment. The consultation process is a great opportunity for us to hear feedback on these options that I've just outlined, and we welcome submissions on any of the specific consultation questions in the papers, as well as feedback on the framework as a whole. And the input that we receive through the consultation is going to inform the design of the regulatory framework, including the automated vehicle safety law. So I think I've taken up more than enough time, so I'll hand over now to Stephen to talk about the obligations on human users of automated vehicles.
Thank you, Alice. We'll move to the next slide, please, and we'll now play a short 90-second video on the role of the National Transport Commission. We will commence playing of the video for all meeting participants, but if it does not start playing for you shortly, you may need to manually press play on your own device. So I'll wait 2 minutes from now before proceeding to allow you to view the video. Thanks, Minna. Thank you. I'll wait 10 seconds in case anybody is finishing watching on their device. Okay, thank you. The next slide, please. National consistency in the automated vehicle regulatory framework. So as we've just heard and seen in the video, NTC is working towards a nationally consistent approach in a range of areas, including for the automated vehicle regulatory framework. The proposed automated vehicle safety law will apply nationally because it is a Commonwealth law. Some existing laws and regulatory systems in states and territories will intersect with the national law. These will need to be reviewed and in some cases adjusted to accommodate the safe use of automated vehicles. We want to take a nationally consistent approach to these changes. NTC will work closely with all Australian governments to recommend nationally consistent approaches to Australian transport ministers. Examples of some of these intersecting areas include state and territory on-road legislation, including vehicle registration, road management, regulation of human drivers and other road users, and human driver licensing. State-based heavy vehicle laws, commercial and public passenger transport, and motor accident injury insurance. Where an intersecting regulatory framework falls under the responsibility of states and territories, we will work with them closely to find a national approach. Where appropriate, NTC will go so far as to develop model laws to help promote that national consistency. However, national consistency can be difficult to achieve. Many of you will already know this. In some cases, state and territory-based laws have inherent variations that make it hard to achieve the same result. Even the road rules across Australia have some minor variations from state to state. Motor accident injury insurance and commercial passenger laws are examples of this. Both are intersecting frameworks that have evolved with differences between jurisdictions. However, there are still opportunities for consistency, and that's what we will seek out. Where we can develop approaches to reform that enable states and territories to follow consistent principles or achieve consistent outcomes, then we think those approaches are worth pursuing. The consultation explores regulation of human users of automated vehicles. I'll now talk more about this aspect of the consultation. So onto the next slide, please. Thank you. Human user obligations for conditional automation. Australian infrastructure and transport ministers have agreed that a fallback-ready user in a vehicle with a SAE Level 3 ADS feature engaged will be required to safely take back control and drive after the ADS has issued a transition demand. A fallback-ready user must respond to an ADS transition demand to take over control of the vehicle, must hold an appropriate driver licence for the class of vehicle, must remain seated in the driving position, is subject to the same alcohol and drug restrictions as drivers of conventional vehicles, is subject to existing fatigue requirements when using a heavy vehicle, and must not perform an activity that impedes them from being ready and able to take control of the vehicle when a transition demand is issued by the automated driving system. A range of other non-driving related road rule obligations will be applied to the fallback-ready user that basically replicate the role that they will alternate with as driver of the vehicle. For example, rules about seatbelt usage for themselves and other passengers, following directions of law enforcement, and assisting in a crash. In some ways, developing policy approaches for Level 3 vehicle usage has been simpler because these vehicles are expected to have a driver positioned in the driver's seat for some portions of the journey. Next slide, please. Obligations for human users of automated vehicles in more highly automated vehicles, now consulting. The consultation seeks community and industry input on how human user obligations should work at higher levels of automation. The aim is for the regulatory framework to take a nationally consistent approach to these issues. I'll briefly touch on some of the areas where we ask questions in the consultation materials. I'll step through them one by one, but we encourage consideration of how these areas should work together as a whole. Vehicle control and seating configurations. We are mindful that future vehicles may look different to vehicles today. Some AVs may have no manual driving controls, such as steering wheels or pedals at all. Others may have manual driving controls installed. Seating configurations could include circular or inward-facing configurations, even in what might be regarded as conventional passenger vehicles. We are seeking industry input on the direction and design of vehicle control and seating configurations, including whether technical solutions and vehicle designs may help to determine the obligations for users of these vehicles. Seating position requirements. Seating configurations in vehicles with higher levels of automation may include layouts where a passenger or multiple passengers have a clear view and access to a position close to manual driving controls. This could affect what is determined to be the driver's seat position. A vehicle occupant may be able to move from a passenger seating position to a driver seating position mid-journey. Although this is possible in a conventional vehicle, the risk does not typically arise because conventional vehicles cannot travel without the presence of a driver. Vehicle designs might include physical barriers or other technical solutions, such as locking out controls. In the consultation papers, we explore a range of options on seating position and ask for your feedback. Driver licensing. The purpose of driver licensing is to ensure that an individual has the relevant qualification and skills to safely operate a vehicle. We need to consider the relative need for this safeguard in an automated vehicle context. Licensing requirements may also be affected by the configuration of vehicle controls in future vehicles. We are mindful that people who are unlicensed may wish to access automated vehicles, including to travel independently where safe to do so. In the consultation papers, we explore a range of options relating to licensing and ask for your feedback. Drug and alcohol restrictions. Drivers of conventional vehicles must comply with drug and alcohol restrictions. This is because drugs and alcohol have been shown to impair driving ability and increase the likelihood of crashes. In an automated vehicle, when a person takes control of the driving task, for example, by using the steering controls, accelerator or brake, they become the driver and are subject to all drink and drug driving laws. In highly automated vehicles, we anticipate that the vehicle type may be able to lock out access to manual controls for some journeys. In the consultation papers, we explore a range of options for drug and alcohol restrictions and seek your feedback. Availability of secondary activities. One of the key potential benefits from the introduction of higher levels of driving automation is the capacity for people to engage in secondary activities when they would have been driving. Secondary activities might include things like working, resting, consuming entertainment, or reading books, newspapers, or magazines. An automated driving system might issue an alert to a passenger when it is approaching the end of its operational design domain to allow a human to take over driving and continue without the vehicle needing to come to a stop. If a user responds to an alert from an automated driving system and chooses to resume driving, they become a driver. The transition from ADS control to human control needs to occur safely and effectively. The consultation explores options on how best to regulate secondary activities and asks for your feedback. Assignment of safety tasks not directly related to driving. The Australian road rules and other state and territory laws specify behaviour for all road users that support the safe and efficient use of roads in Australia. Many rules relate to the dynamic driving task, such as rules about how a vehicle should move around on a public road, such as obeying road signs, using indicators, stopping in appropriate places, and so on. There is also a range of road rule and other obligations that are not part of the dynamic driving task. This includes things like exchanging information with other people if involved in a crash, wearing a seatbelt, rendering assistance, and ensuring passengers, including children, wear a seatbelt or proper restraint. Without a human driver to assume responsibility for these and other obligations, these non-driving obligations will need to be reassigned to other parties in order to maintain existing levels of safety, cooperation, and social responsibility among road users. Other parties to whom obligations could be assigned, depending on the circumstances, include the automated driving system entity, a commercial or fleet operator, the registered owner of a vehicle, one or more passengers travelling in the vehicle, or a new category of human user, such as a supervisor, steward, lead passenger, or an operator who engages an ADS. The consultation explores options for assignment of non-driving task obligations and asks for your feedback. Next slide, please. Factors to consider. There are a range of factors to consider for human user obligations in highly automated vehicles. We set out some relevant factors here on this slide, which I'll speak to briefly. Rethinking traditional approaches and assumptions. Traditionally, road rule obligations have been built around the assumption of a licensed human driver being in control of the vehicle. This traditional role and way of thinking may not be appropriate as we look ahead to highly automated vehicles. We may need to challenge our traditional thinking about who will be in the vehicle and who can reasonably have an influence over the safe and efficient operation of the vehicle. International technical vehicle standards. Work on technical standards for automated vehicles is ongoing in international forums. We will continue to monitor how these vehicle standards progress and if those standards have a significant bearing on how human user obligations should be designed in an Australian context. Assigning obligations in a fair way. We want to make sure that any reassignment of obligations is done in a fair and reasonable way. We don't want to place obligations unreasonably or unfairly on vehicle users, which will be too difficult or impractical for them to fulfil. A safe and efficient road network for all road users. We want to ensure a safe and efficient road network for all road users, not just those using automated vehicles. We anticipate a mixed fleet of vehicles on public roads for a long period of time. In this context, we want to ensure that AVs are safe and that safety risks are appropriately managed by those who can have control over them. Maximum opportunity for all Australians to access AVs. Many automated vehicles could complete entire journeys without requiring human control or receptivity. These vehicles could provide an independent transport option for people who are unlicensed or who cannot drive. We want the regulatory approach to enable access to automated vehicles. Feedback from this consultation. We will consider all feedback from this consultation in continuing work on designing human user obligations in highly automated vehicles. We hope that this will include information and input from all segments of industry and technology providers, and also community perspectives on what people expect. All of this input will be critical for moving forward effectively. In the consultation papers, we touch on a range of other issues that are relevant, including uncertainty in technology development and enforceability considerations. On to the next slide, which is next steps. The current consultation process is an opportunity to hear your feedback. We welcome submissions focused on any specific consultation questions in the papers and also on any element of the regulatory framework in general. The input we received through this consultation will inform the design of the regulatory framework, including the proposed automated vehicle safety law and changes to state and territory laws. The consultation closes on 11 June. Please see the website link to the consultation materials where you can have your say. Thank you. I'll now hand back to Michael to conduct the question and answer segment of this session.
Thanks very much, Stephen, and thanks, Alice, as well for earlier. I think a really good detail there presented to everyone. My colleague Mina has just put a link in the chat for anyone who wants to look at the consultation material as we discussed today. So as mentioned at the start, I will throw it open to question and answers. So for anyone who might like to ask a question, you can do so by raising your digital hand and I'll come and give you access to your microphone. But there was one from earlier in the chat from Jake. And I think this is for you, Alice. I'll call it out first, but I might give you, I will give you access to your microphone as well. Jake, if you'd like to respond to it in a bit more detail. So just your microphone's allowed there. And if you'd like to go ahead.
Yeah, thanks very much. Yes, look, I'm in the insurance industry, so our interest is particularly about being able to get data from accidents, and then also, so yes, just that question about will they be an Australian entity? Will they hold capital? So it's for us to be able to get data, and if they have a liability, that Any clarity on that question?
Yeah. So it's a great question. So in terms of the certification process for an entity to become an automated driving system entity, there's a few different requirements that have been proposed. So one of those is about their corporate presence. We've actually got questions about this in the current consultation about what corporate presence in Australia should require in the context of the AVSL. So the agreed policy framework just required a corporate presence in Australia. We are now looking at that in a bit more finer grain detail about kind of what's the minimum requirement. And so examples of what that could include is that you're an Australian registered company, or you're a foreign company that's registered to do business in Australia. But also elements of those certification requirements include things like being able to show you have document access and control around key documents that the regulator may need to conduct its role. There's a financial capacity element of the certification requirements. So that's about having evidence that the ADSE can kind of cover the expenses of meeting its ongoing responsibilities under the Automated Vehicle Safety Law, and that would also consider things like whether they have appropriate insurances. And then there's also requirements at certification about data recording and sharing capability. And that, I guess, also recognises that it will be important, not just for the regulator, but for also, you know, the police, for individuals, for insurers, to be able to access information from, you know, about whether the automated driving system or a human was in control of the vehicle at a point in time, to help settle things like liability after a crash. Does that help, Jake?
Yeah, that does, Alison. Just one follow-up related question around the data ownership. I don't know if there's been any connection to that question of who owns the data, whether the owner of the vehicle owns the data, or whether the manufacturer or the ADSE owns the data. Is that being looked at, that question?
So I don't think it's been looked at in detail in the context of the Automated Vehicle Safety Law. I think it's the focus has been on making sure that people who need access to the data are able to access it, rather than focusing on who owns that data. So yeah, apologies. I don't have a hard and fast answer to that one.
No worries. That's great. Thanks very much, Alex.
Thank you very much for that question. I think we had one more in the chat from Bastian. Yeah, I think you had a few comments there on marketing and communications as well, but you did have a question: is there a plan for alert sounds and systems to be consistent between vehicles? Noting this might be ideal to improve legibility and accessibility. I could just give you access to your microphone if you want to add anything further to that, Bastian. Otherwise, I might just throw it to Alice or Stephen to maybe provide a bit of detail to that.
Look, it's just something that I mean, obviously, on automated vehicles and vehicle systems are getting quite complicated, and what we wouldn't want to do is to have somebody confused at that critical point in time. So having a consistent sound that it doesn't matter if you're going between vehicles, especially if we're contemplating, say, share car services or those sorts of things, it would be really important that at the very least that alert sound could be consistent so that it could be legible for people. But also, if people use assistive technologies like hearing aids, etc., you could actually program it so that that's picked up as a critical thing.
Yeah, so I might jump in and attempt to answer this one. So I think your question really goes to the design standards for an automated driving system. And that's not something that I'm an expert on, so I'll confess my lack of expertise. So I've got other colleagues in the department that are focused on developing the vehicle standards for automated driving systems. In Australia, to the extent possible, we tend to harmonise with the United Nations standards on vehicle design. So, you know, things like having consistent alert sounds is certainly in the vehicle standards space rather than the in-service safety law space, because it is about how you design your automated driving system. So we're participating in those forums. And you know, I guess influence them to make sure that the needs of the Australian market are considered in setting those standards. So I can pass on this information to the people that work on the vehicle standards, because I think it is it's a pertinent point. But yes, I don't know whether having consistency of things like audible alerts or feedback alerts have been contemplated there. In terms of the in-service safety law, though, there is requirements on the automated driving system entity to provide education to people that use their ADS to ensure that they understand how it operates and, you know, are able to use the system safely.
Sure, thank you. It's just I wouldn't want, for example, a hearing aid system or a cochlear implant to, that the sound selected is not very detectable.
Okay, yeah, that's a very good point.
Thank you very much for that, Bastien. Do we have any more questions for our colleagues here today? Going once, going twice, gone. Sorry, we do have one. Peter, you just beat the deadline. If you want to, sorry, I'll just provide you access to your microphone to ask your question to our presenters. So you should have access now, Peter. Sorry, can you? Oh, sorry, it looks like Peter is unable to access his microphone at the moment. Maybe if you put that in the chat, Peter, if that works for you, and we can put it to our presenters. Just while we're waiting that. Okay, sorry, thanks, Peter. That's coming there. So I'll just call out the question. Could you please elaborate the difference between state and Commonwealth in approving AV trials?
Yeah, I'll jump in on that one. So at the moment, state and territory governments are responsible for managing automated vehicle trials. And I don't think we're intending to kind of remove states and territories from that equation at all. So I think what we are trying to propose with having the new automated vehicle in-service safety regulator having a role in trials is using that as an opportunity to better understand how our regulatory frameworks work in practice, to kind of tease out some of the nuance and complexity of doing that regulation, and to hopefully support larger scale trials, before we are ready for commercial deployment. So I think the difference might be that having that Commonwealth factor might make coordinating, a cross-border trial, for instance, work a bit better. But I will say that the proposals in the consultation papers are at a quite high level at this point. So we're really quite interested in feedback from stakeholders about, is there things in the existing way that trials are managed that are, creating a barrier to those trials, larger scale or more complex or cross-border trials occurring. So yeah, we're definitely in kind of information gathering mode on that front. But then one option we're looking at is, do we provide a pathway under the automated vehicle safety law to do trialing, with the idea that that helps us understand more, that will help us do the in-service commercial deployment of automated vehicles better when it's time.
Perfect. Thanks very much for that, Alison. I hope that answers your question, Peter. And yes, no, thanks in the comments. Appreciate that. I think we have one final question, and back to Jake on insurance and liability. I should have access to your microphone again. Jake, if you'd like to put that to Alice or Stephen.
Thank you very much, Michael. So yeah, just to clarify, so you mentioned, so when we've got a level 3 vehicle where basically a human essentially has to be on standby to take back control if they're told to be. My understanding is, even though it's of course a little bit grey, is that from an insurance perspective, particularly I'm in the personal injury insurance, where the insurance policy covers the negligence of the driver, that essentially the driver is still the responsible entity. So I'm just wondering, in terms of when we get to level 4 and 5, that's where I think we move out of that realm and it's into the, basically the automated driving system that is the liable, the responsible entity. So I'm just wondering, is there an expectation that this this legislation and the proposed new regulator would just be coming in at that level 4 and 5 automated system, or would it also have jurisdiction and over the, shall we say, the more the driver assist rather than the full automated driving system? I don't know if that question makes sense.
I might just clarify something, which is that a level 3 is an automated driving system. So that's conditional automation. When the automated driving system is in control, it is performing the entire dynamic driving task, and a human in the seat doesn't need to be supervising the system, but they do need to be alert enough to take back control when there is a transition demand. So level 3 is in scope for the automated vehicle safety law. That being said, I've been cautioned that, you know, talking about the SAE levels might not be the most useful tool to use. But I guess to go to the nub of your question, liability will also always depend on the facts of a particular case. But under the automated vehicle safety law, when the ADS is engaged, the ADSE is responsible for its safe operation. So even in a level 3, a vehicle that has level 3 automated features, when that ADS is engaged and controlling the vehicle, the ADSE is responsible for that occurring safely. And similarly, at level 4 and 5, whenever the ADS is engaged, the ADSE is responsible for ensuring that safe operation. So that's, I guess, how we see the responsibility piece sitting, but happy to answer any follow-ups you might have from that.
Okay, thanks, Alice. Yeah, so it is 3. I mean, if you get down to 2, and I understand that the levels are a little bit, not precise, but essentially, even if the system is, shall we say, in control just for a minute, it's still responsible for that minute. It's only when you get down to the sort of the lower levels that it's sort of a driver assist that you would have the onus, essentially the liability would be more on the human driver. Have I understood that? Would that be how you describe it?
So I guess once again, for clarity, at a SAE level 2 of driving automation, the system cannot perform the whole dynamic driving task. It can only perform part of it. And so anything below SAE level 3 driving automation feature is so 2 and lower. A human is always in control and responsible for the safe operation or safe performance of the driving task, even if the system is supporting you by things like, lane keeping and adaptive cruise control. Probably one other clarification I'll make is at the level 3 and higher, there's an intention to have a system. It's called a data storage system for automated driving. So the requirements for this is still being developed in the international forums, but the idea of that system is that it keeps a log of whether it was a human or the automated driving system in control at any point of time, whether the automated driving system had issued a request for the human to take over driving, and whether it performed things like a minimum risk maneuver, which is trying to pull over when the ADS can't handle the situation anymore. So we'll have a log of those transitions of control, which will also help clarify who was or who or what was in control of the driving task at any point in time.
That's really helpful. Thanks very much.
Thanks very much for the question again, Jake. And that's time for today's webinar. We do hope you found it, got quite a bit of information from it today and useful for your own understanding. So just before closing off, as we put in the chat a link to the consultation, we do encourage as many of you as possible to put a submission into us before, I think it's 11th of June, consultation closes. But there's also a few options on our webpage as well if you'd like to request a meeting with NTC and the Commonwealth. We work very closely together on this. If you'd like to catch up, just discuss things in a bit more detail with ourselves. So with that, again, I'll just thanks Stephen and Alice for today, and we look forward to hearing from you again shortly. Thank you.